If you don't plan, you're stupid.
Welcome to If You Don't Plan, You're Stupid with estate planning attorney Andy Rosenberg. Andy is a Florida estate planning attorney who helps families protect their legacy and avoid costly legal mistakes. I'm your host, John Clements. Today we're digging into probate. We're going to talk about what it is, why you want to avoid it, and how a good estate plan can keep your family out of court. So before we dig into that though, Andy, welcome to the show.
Thanks, John. I hope everything's well with you.
I think it's well enough. I'm excited to talk to you, though.
Yeah, me too. I'm excited to talk about it, and I'm all happy because the Florida Panthers just won the Stanley Cup.
Awesome. Well, congrats to them and to you by extension.
Yeah, thank you. Thank you. All right, my friend, tell me what you want to talk about today.
I want to learn about probate because I keep hearing this word and I don't know what it is. So what is probate and why does it exist?
So the best way I like to describe probate is it's just a court process. That's all it is. It's just a fancy word that we use for a specialized court system when someone passes away. So what happens, John, is that when someone passes away and they have assets that are in their name alone, okay, there's no beneficiary form or anything like that, or there's no joint tenancy or anything. They have a house in their name. They have investments in their name, bank accounts in their name, and they pass away. In order to legally transfer the assets from the deceased person to wherever it needs to go, we have to go through this court process, and that court process is called probate court. Now, the issue is I can only tell you about Florida, so I don't know how other states handle probate because some states, we're all different in some respect. But in a nutshell, that's what probate is.
So it seems like it should be a straightforward process, but I'm going to go ahead and guess that it's not always a straightforward process. So what kind of problems
it's definitely not always a straightforward process. Yeah. Probate is very form driven. So there's lots of forms to do it. We handle probate every day in my office. So the forms are very, it's very mundane as far as the forms, but unfortunately, when you get people involved, it gets pretty interesting and unique. So that's usually what happens is there's lots of variations of a form-related system that gets screwed up because we have issues and things that pop up when it comes to people and when it comes to money and inheritance issues.
So is it generally the case where that you just run into complications with these probate court trials, or is it sometimes the case where, like, to what extent is it a problem?
First off, I try not to take cases that are going to be problems.
That's good point. Good point.
I don't want them. But I would say most of the time, John, they're not problematic. Okay, there are little changes here and there that have to happen that you have to deal with within each particular case. But in general, I like to describe the probate process as there's a beginning, there's a middle, and then there's an end to the process. And in the beginning process, at least in Florida, there's a lot of paperwork that we have to have signed and witnessed and notarized and all that good stuff. And then what happens is once we have all that stuff signed, we actually send it to the court. And then hopefully the court's going to approve it, or they're going to kick it back saying that we have a couple of issues, please fix them. So once we fix them and we send it back and everything's good, at that point in time, what's going to happen is the court's going to issue us a case number. Once we get to case number, then what happens is if it's someone that died without a will, called dying intestate, so dying without a will is called dying intestate, what happens is we have to send in a certified death certificate to the court. And then once we send that certified death certificate to the court will issue something called letters of administration, which is, you probably heard the term, John, of an executor.
Mm-hmm. Yeah.
Okay. So in Florida, we don't call the person in charge an executor. For whatever reason, Florida calls it a personal representative, or PR, but it's the same thing as an executor. So the letters of administration that name the PR, or personal representative, as the person in charge of handling the probate process with court supervision. Once we get those letters issued, signed off by the court, saying that John Smith is now the person in charge of the Smith estate. Then what happens is we have to file in a newspaper for 2 weeks in a row documents, right? And then we have to wait 3 months to see if any creditors file against the estate. So the whole process from start to finish, just the beginning process, is usually 3 to 6 months, because it takes a while to get all the paperwork signed by the client and then sent into the court, and then getting a death certificate approved, and then getting a case number, and then getting the letters issued, and then filing in a newspaper for 2 weeks and waiting 3 months. So before you know, it's 3 to 6 months before anything's going on. So that's like the beginning.
Yeah.
Right? The beginning of a probate. Then we got the middle, which is where we have to file an inventory. We have to liquidate the assets and open up what's called an estate bank account and liquidate the money and put everything into the estate account and do all those types of things. And then there's the ending, which is, okay, we know that we have a couple of creditors. We got to pay off these creditors with the money that's in the estate bank account. We got to get them to sign off saying that they've received payment and they're satisfied. And then we got to distribute assets to all the beneficiaries and make sure everyone gets their fair share. And then we can file with the court something called a petition for discharge. And then at the end, the judge will sign something called an order of discharge. And once that's done, the case is over. So that's why it's kind of like the beginning, a middle, and an ending for this court process. The problem, John, is the court process takes time. It doesn't just, it's unfortunately, on average, I would say it takes 15 months or so to get this done, or longer. If you're lucky, you can get it done less than a year. In fact, what happens with the courts, at least in Florida, John, they make us sign something saying that we're going to do our best to try and finish this estate out within 1 year or less. But it hardly ever happens, because there's just so many issues that crop up with the court system in probate court. So that's the process of probate. And what people need to understand, John, when I do all these workshops all over the place, that people don't understand this. And I blame the movies for this. People think that if you die without a will, which I told you is called dying intestate, that you go through probate court, right? But people think that if you die with a will, okay, that legal term for that for everybody is called dying testate. So without a will, intestate; with a will, testate. But people think that when you die with a will, that if you have less than a certain amount of money, that it just goes. It just gets distributed. And that's not the case. I watched a movie a couple months ago for probably a third time. Great movie, by the way. Gran Torino. You ever see it with Clint Eastwood?
I haven't seen that one. No.
That's a great movie. Watch it. Great movie. But anyways, at the end of that movie, spoiler alert, so turn this off if you don't want to know what happens. At the end of the movie, the Clint Eastwood character gets killed. And it ends in an attorney's office. And the attorney is reading the will. And there's all the beneficiaries in the room. And then you see the one of the beneficiaries driving off with the Gran Torino in the sunset, and the credits are rolling. And that's the end of the movie. They forgot to tell everybody that you got to go through a year and a half of probate before that happens.
That probably doesn't make for quite as exciting cinema, so I guess I'll give him a pass on that one.
Yeah. So I hope that helps explain what probate is.
Yeah, it really does. And so you mentioned it may take a year or less, but that's probably not realistic. Probably going to take 15 months or maybe even more. So talk to me about what are some things that either can gum up the works or things that you can do to make it go faster? Like, how can you affect that timeline?
It's hard to. It's very hard to. First off, it depends on the type of probate. So I didn't mention. So in Florida, there's typically 2 types of probate. So if all the assets that we talked about earlier, if it totals less than $75,000, there's like an accelerated version of probate. It's called a summary administration, and that can happen lickety split pretty fast. It can happen within a month or two, and then we're done. So we got that. So that's one way of speeding up the process. If we know it's less than 75,000 of assets, and we had certain factors are determined, we can do the summary administration process. If it's not that, then it's going to be the normal formal probate that we just discussed. And unfortunately, there's no fast way to get through this process. And the problem is, I live in South Florida, and the Tri-County area, Miami-Dade, Palm Beach, Broward counties. And the problem is there's a lot of people that die. I mean, it's an elderly population, and there's only so many judges per county that are doing the probates. So if you think about, we got too many people dying, obviously, in this market. We have only a limited number of judges. Then we have issues like emergency hearings that crop up for the judges. We have federal holidays, right? The courts are closed. We have judges that get sick. We have judges that go on vacation. They're people just like us. And so all this lends to delays, and there's not much you can do. I mean, I will tell you that a lot of times I'm dealing with clients in probate, and I'll get them the documents and they won't sign off on the documents fast. It will sit for a month or two, and that screws things up too. So if you want to know a fast way to help, is that when the attorney gets you the documents, review them and sign them quickly.
Yeah, I can imagine. Yeah, with everything else going on, you don't want to add to that delay, because I'm sure like you want it to be resolved just like anyone else. So yeah, that's a good tip. How about just straight up avoiding probate? Is there a way to do that?
Oh, there's tons of ways to avoid probate. My whole workshop that I do on a regular basis talks about the actual probate process at the beginning, and then the rest of the workshop is how do we avoid this stuff. So there's all sorts of ways to avoid it. Titling of assets is one way to avoid probate. Beneficiary forms is another way, which we'll talk about. What else is there? Obviously, trust work is a way to avoid probate. So there's lots of ways to avoid it. Again, if you were careful about what I said at the beginning of this podcast today, you heard me say that if the person passes away and they have assets in their name alone and there's no beneficiary to it, then that's probatable. So what happens if we don't have assets in someone's name alone? Let's say that, John, you and I own an investment property together, and we own it as joint tenants with rights of survivorship, and then I die. So then does that go through probate? And the answer is no, because the way legal ownership for titling of asset with joint tenants with rights of survivorship, it means when someone dies, it goes to whoever is surviving. So if I were to die, it would automatically go to you, John. There's no probate. So that's one way to avoid probate, is all sorts of ways to title assets. Another huge way to avoid probate is to have beneficiaries on accounts. So IRAs, 401ks, life insurance, annuities typically all have beneficiary forms. So you want to make sure that you have a proper beneficiary named, so that when you do pass away, whoever you name as the beneficiary will get it with a death certificate. There's no probate. So again, that's another way. I will tell you, John, that I have lots of scenarios where we have assets that have beneficiary forms and we're doing probate. And the reason why, number one, the person never named a beneficiary. So then if you didn't name a beneficiary, it's got to go to the estate. And therefore, if it's going to the estate, it's got to go through probate court for the proper legal documents. The second reason why qualified accounts, IRAs, 401ks go through probate is the person didn't name a contingent beneficiary. So let's say that they have a primary beneficiary they named, and that primary passed away. So then we want to go to the contingent or alternate beneficiary, and they never named anybody. So now we're going through probate again. So titling of assets, depending on how things are titled, are ways to avoid probate, and there's lots of issues to be concerned about. That's a whole separate podcast we'll talk about. Beneficiary forms, avoid probate, and then trusts, avoid probate. And that's a whole separate topic that we're going to have a podcast on, because trusts are complicated, but I try to make it as simple as possible. But yes, there are definite ways to avoid probate.
Awesome. And then I did want to just mention or get your thoughts briefly on this idea that there's probate, and then there's something called guardianship court. Just real briefly, can you explain the difference between those two things?
The best way I like to describe guardianship court is what happens if you become disabled or incapacitated and you can't handle your financial affairs. If you don't have the proper legal documents in place, then there's a separate court system for that called guardianship court. So the difference between probate court and guardianship court is probate court over here is dealing with death. Guardianship on this side, on the other side, is dealing with disability or incapacity. So I like to describe, people know this, and I mentioned this a lot in the workshop. If you remember Britney Spears, the singer.
That's who I was thinking about. Yeah, exactly.
Yeah, you remember that whole fiasco that was going on with her in California with her dad and the court system and all that. Well, so in California, they call a guardianship a conservatorship. Same thing, it's just a different term. So obviously Britney had some mental issues or whatever, and they deemed her to be incompetent. So she couldn't handle her financial affairs. So she's over 18 and couldn't handle things. So what happens? She doesn't have the right documents in place. So the courts got involved, and the courts named her father as the person to handle everything. And obviously we saw what happened. Her father mishandled all the money and took some of the money and just did inappropriate things with it. And it was a huge fiasco. And she eventually became capacitated again, and they basically got rid of the guardianship. But that's a perfect example of a guardianship and why we don't want to go into one.
Yeah,
but those are the differences. Probate is for death. Guardianship is for incapacity.
Great. That's super helpful. Appreciate that distinction. And then finally, Andy, today, people in Florida are listening and they're saying, oh my gosh, this probate sounds like hell. How do I avoid it? What's the first thing you would tell someone to do to avoid probate?
First thing I tell them to do is they should meet with someone like me, an estate attorney, and go and meet with that person, he or she, and tell them what their goals and their concerns are and what they want to try to avoid. And then hopefully you'll have a competent attorney that will be able to handle things and they can give you the proper input. When you meet with this attorney, you should have all of your accounts. So the latest statements, investment accounts, IRA accounts, 401k accounts, brokerage accounts, real estate titling of things, all this stuff, because we as the attorney are going to want to know how things are titled so that we can determine how things will disappear or distribute, I should say, when you do pass away, to see if is it going to go through probate? Is it not? So my answer to that question is meet with a competent estate planning attorney. That's how you should do this. Don't do it on your own. There's lots of crap out there, and it's crap. And, I always tell people, I don't do things on my own when it comes to like selling real estate. I hire a real estate attorney. This is your estate plan. This is for you when you pass away, to make sure things don't get screwed up when you pass away and it goes smoothly to wherever you want it to go. Hire a competent estate planning attorney.
Yeah, well, I think the last 20 minutes of our conversation have proved that to me. So thanks, Andy, for coming on and sharing of your wisdom. It's just been super helpful, man.
Thanks, buddy. Appreciate it. I look forward to talking to you soon.
Thank you. And to our listeners, hey, probate is slow, expensive, and public, but it's also preventable. If you want to protect your family, visit rosenberglawfirm.net and let's make a plan. And don't forget to subscribe, leave a review, share this with someone who thinks a will is enough, because it's not.
Thanks, John. Talk to you guys later.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.